Hello and welcome to today's session. I'm Julian Wilkins, legal commentator for Automotive EV. Today's session is the first of three talks over the next couple of months relating to automotive vehicles. One may say, what automotive vehicles to do with electric vehicles? And one of the key issues is that research has shown that automotive or self-driving vehicles arguably are more efficient in terms of traffic management, more fuel efficient, and take out some of the human aspects. Each human acts and reacts in different ways in any given circumstance, and the view of research is that vehicles, if automated using complicated software, artificial intelligence, may lead to safer and more efficient use of the roads and in turn energy, whether it's electric or otherwise. It's a long road, and obviously there's, like me, I'm a keen driver, and I still like to think that in time to come there will be a role for you being able to drive your own vehicles. But that said, vehicles becoming more and more technical, use of software, and we already see this, whether it's cruise controls, anti-lock brakes, automotive lane keeping systems. So it's a gradual move towards automated vehicles, but it is a long road. There's a lot of technical complexities, and there's also going to be a lot of legal and regulatory issues. And there's a bit of a chicken and egg there. The technology may be there, but do we have the right legal framework? And in particular, issues to do with risk and liability. What if something happens? What if there's an accident caused by an autonomous vehicle? So this talk today will be looking at some of the new regulations that have come in via the United Nations World Forum for the Harmonisation of Vehicle Regulations. And there's already some initial framework legislation, the Automated and Electric Vehicles Act 2018. It's a start, it's not a finish. It gives some framework to how the laws in relation to automated vehicles will operate in practice. Currently, as the Law Commission are doing a number of consultations about the law and policy. In fact, they've just had their the third consultation that was published in December 2020, and consultation closed in March. They hope to report towards the end of the year with their suggestions on future legislation and general policy. That will be looking at all aspects, whether it's the rules to do with technical issues, privacy, data, the civil liability issues, what happens if there's an accident, who's liable. You've got a very complicated supply chain issue there. Is it the manufacturer? Is it the owner or keeper of the vehicle? Is it the software developer or manufacturer? So all these things are being considered, but it will be considered in the light of what's going on a wider platform, and that's what we'll be talking about today. Probably the most significant steps towards looking at the automotive vehicle infrastructure is what's coming out of the United Nations World Forum for Harmonisation of Vehicle Regulations. And this year, 3 regulations were introduced. The first one is to do with protection against cybercrime, and also the management systems to protect against cybercrime within the setup of the vehicle. The second regulation concerns the software updates, and the management of software updates. As we know, cars like Tesla have regular software updates to do with battery efficiency, improvements in ride handling, whatever. And that will become an increasing part of the car, uploading and constantly monitoring and updating and improving the service and systems of the vehicle. It's no surprise that manufacturers like Volkswagen, for instance, are recruiting heavily to effectively develop their own in-house software departments rather than being so dependent on external providers. There's various reasons for that, and I suspect the two core reasons is one, protection of intellectual property rights. We've developed software, we own it, we want to exploit it. And the other aspect to it is liability issues. If you're developing your own indigenous software for your own products, it's a lot easier than necessarily being dependent on third parties. There's some generalization there, but that, I suspect, is some of the thinking behind them. Going back to the regulations, and just give some context that at the moment there's vehicles that are either level 0 or the maximum one, which is level 5. Most vehicles probably fall somewhere in level 0. You've got anti-lock brakes, cruise control. Vehicles are probably gradually going to get to level 3 in terms of being legally able to operate at level 3. That's where the car can take over in certain given circumstances, not all circumstances, but the driver must be available to immediately to come back to take over from the vehicle if it gets to the point the vehicle can't, or it's more appropriate that the driver takes over given any particular situation. Now, this is an area of huge debate because there's the issue of response times. You're going along, the car's in control, you're just sitting there, and suddenly something happens and you're advised that you've got to take back over. Now, how quickly do you react? Is it quick enough to deal with the situation? And this is an issue that's been addressed to a degree in one of the new regulations, one of the UN regulations, to do with automated lane keeping systems. And at the moment, the rules are looking at sort of defined situations, maybe the vehicle going no more than 60 kilometers, ballpark 30 miles per hour, 37 miles per hour, but with the view to the driver taking back over in a given circumstance. Now, the regulations that they've introduced are quite complex. In fact, the most complex of the 3 regulations that I've mentioned and very detailed. Because of that, we're going to do that in a separate session for today. I'm just merely flagging it, but it's interesting. It's going to include constant data monitoring. There's going to be a black box equivalent to what you have in an aircraft. So, it keeps a monitor of what the software is doing, but also the reaction times of the driver and so forth. So in the forthcoming session, we will look at AUX, automated lane keeping systems, in more detail. But it's out there. In fact, it's the first set of regulations in the world to do with this. We hear in the press about possibly by the end of the year there'll be sort of self-driving vehicles or some type of self-driving vehicle in certain situations on UK rules. Well, it will be, I suspect, implementation of that regulation without getting too bogged down in the complicated ecosystem of the law and regulations. The UK are a signatory to the harmonisation, UN's harmonisation of vehicle regulations, and so we will be adopting that regulation or some form of it. In terms of the other regulations, the first one I'll be talking about is the in relation to cybercrime and the systems on a vehicle, not just the vehicle, but in every stage of the vehicle's life, to do with trying to avoid or mitigate the risk of cyber attack. We've seen all sorts of horror stories in the press recently, the oil pipe crisis in the States. The Republic of Ireland recently had a malware attack on the NHS system. A few years ago, there was some allegations about Jeeps being hacked. and that was dealt with very quickly at the time. So it's one of the big worries of the brave new world of technology, whether it's a semi-autonomous vehicle, fully autonomous vehicle, or just a vehicle with a lot of tech. And a lot of cars, even the most basic cars now, have a huge amount of tech on them. And as we know, the phrase sort of like computers on wheels is very true, but it also makes them very vulnerable to attack. So what's happened is that a set of regulations has come into force, came into this year, and basically this covers the vehicle, if you like, from cradle to grave, or from development through production through to post-production. And manufacturers will have to seek type approval as to their management systems to do with mitigating or preventing cybercrime. Now, just one thing, this regulation applies to 56 countries, because there's only, not every country is a signatory to the original 1958 agreement that gave rise to the World Forum for Harmonisation of Vehicle Regulations. That two key people who are not members of that 1958 agreement is China and the US. However, they are members of another UN agreement, the Global Technical Services, and it was or standards, which came into effect in 1998, and that China and the US are members of that. In fact, actually, China and the States took a very significant role in the development of the regulation to do with automated lane keeping systems, which we'll be talking about in another session. And just before I go back to cybercrime, just as another aspect is that the UN now allow for a universal type approval, whereby the whole of the vehicle can be type approved, and this could be the forerunner for maybe one type approval and one technical standard on a universal basis. It's not there yet, but you can see it creeping through as time goes along. At the moment, the US, China, India, for instance, another one, they still keep their own type approval systems. That said, they are very much adopting and using the regulations that's coming out from the World Forum for Harmonisation of Vehicle Regulations. So you can see how there's because of the use of technology, that over time there could be one universal standard, one type approval system. Let's say we're not there yet, but AUX is a sort of glimmer of hope on that level. Going back to cybercrime, basically what a manufacturer has to do for each country within the World Forum for Harmonisation is to produce a risk assessment based upon criteria actually specified in the regulation, looking at all areas or most of the foreseeable areas where there could be an attack on the vehicle, whether it's during the development stage, through production, and then into the open market, and even post the end of production, because the way the regulations are written, it talks about until no further vehicles are in use. So basically, a risk assessment has to be created and tested to see whether it stops or mitigates risks of cybersecurity. That has to be submitted to the approval authority. Each country will have its own approval authority. The manufacturer may have to share sensitive technical information, sensitive intellectual property, but that remains confidential. That's not shared with other contracting parties, other nations subject to these regulations. What is shared is the methodology and the test results, and the plan is that all the countries are basically going to create a large database about different methodologies, how each contracting state is putting together their cyber testing, their cyber testing, and the aim is to develop good practice. So we really are in frontier countries, because I can see the situation where many countries will have very similar systems, and I'm aware that the ISO standards are being used for testing in various circumstances, and they may well be the benchmarks going forward. But the aim is to develop a common good practice over time, and also with language as well, clear understanding on what is in terms of definitions, interpretations of technologies and terms. So it will become more and more. I think the aim is to develop a very uniform system over time. Going back to how it works, at present, the manufacturer has to present their reports. It has to be benchmark tested. It could include sampling. That could be the whole vehicle or aspects of the vehicle, to see how resilient it is to cyber attack and what will happen, or how do you counter any potential attack. And it's just not the vehicle itself. It's also looking at your systems during development or manufacture. What on the production line, are there opportunities for, say, people to deliberately or inadvertently manipulate the software, or do something with the software that could corrupt it, for good, either by inadvertence or for less well-meaning reasons. But so it is a very analytical, very granular assessment, and it's also, the other aspect is that it's an ongoing process. If you get your type approval for your systems, you have it for 3 years. That said, each year you have to report at least once, maybe more, to identify your monitoring systems, because the manufacturers are under obligation to monitor the systems to see whether they meet all the risk assessments and are still, if you like, fit for purpose. And there's an obligation to report any cyber attacks or attempted cyber attacks and what was done to deal with it, and share that information with all the contracting parties, again about keeping this awareness and creating this data bank of information. If a manufacturer fails at any point in sampling or to keep with monitoring obligations, then they could lose their type approval. The other aspect of this is a gradual introduction, because within the regulation it talks about vehicles developed before the 1st of July 2024, if they can't meet all the criteria, the manufacturer only has to show that they gave adequate consideration to cybersecurity and that they took what they could, because it may be that there are vehicles in development now that are so up the line that they may be able to deal with certain cyber issues and resiliencies, but not entirely. So there's a little bit of wiggle room for manufacturers until 2024, but post 2024 it would become, I imagine, a lot more rigorous. In terms of all the data that's collected, it's got to be kept for at least 10 years post ending production of the vehicle. As I mentioned earlier, the going from the definition, they talk about it being applicable during the vehicle's lifetime and until that particular type of vehicle has ceased to be in use. So one will need to consider, does that mean that the monitoring and the accountability stops 10 years after production stops, or is it an ongoing obligation until each and every vehicle of that type is no longer on the road? I think that's going to be a discussion area. I'm just relying on how the rules are written at the moment. It's not quite totally clear and I think that would be open for discussion and as to where the obligation to constantly monitor, update regarding a particular vehicle ceases. Another factor about these regulations, they apply to cars and trucks. In certain situations, they may apply to three-wheel vehicles and also to motorbikes, but in situations where the vehicle already has level 3 equipment on it. So, as I mentioned earlier, it may have a lane keeping system where the driver can drive along, letting the car do the driving, as it were. And that if it's a level 3 type of vehicle, say a motorbike or three-wheeler, then these regulations would apply. The other set of regulations is about the software update. In certain respects, they take a similar format to that for cyber management, and basically the manufacturer has to have a system that they can show that when they download any updates, that it is compatible with existing software, that it will not affect external equipment. For instance, that could be quite important when we have more and more autonomous driving, because the car will be talking to other cars, be talking to sensors and so forth. So they need to demonstrate that whatever goes on the vehicle isn't going to be corrupted or corrupt. They're my words, but that's really the tenor of the regulation. And again, it's using benchmarks, correlating the software against the downloaded software against existing software to make sure that they're compatible. So these systems have to be in place before the car can get type, or the vehicle can get type approval. And also the other thing is this regulation is much more expansive. It applies to effectively any type of vehicle, whether it's 4-wheel, 2-wheel, 3-wheel trucks and so forth. So it's really any vehicle that's on the road. So the type approval system has to demonstrate that whatever software goes on will be compatible. Now, if you get your type approval, you've got it lasts for 3 years, and after every 3 years it gets reviewed. Running alongside that, if you do any significant changes in software or your systems, that it may lead to having the whole vehicle retested in terms of its software capability to do updates. And the other factor is that the type approval authority can do sampling throughout and to see that the systems are still resilient and meeting the criteria which you set. One thing about the criteria at the moment, as the regulations are written, is a reasonableness test. You have to show that you can reasonably prevent or mitigate against the software becoming corrupted or incompatible. So this is going to be interesting to see how this operates in practice, because if it's a reasonable test, that what is reasonable, and and you may get variance between different type approval authorities, between different manufacturers, as to what is an acceptable level of compatibility and unacceptable level of compatibility. Again, like a lot of these regulations, they're introduced, and it's the implementation over time and the refinement that will help hone the matter. Again, a lot of manufacturers are looking to the ISO standards, so maybe that will help build uniformity and consistency into standards. Couple of key features about the updates. The rules or the regulations allow for the fact if the download is unsuccessful or can't be completed for whatever reason, that the system has a system whereby the software defaults to the original settings. So in other words, you try to download or update the software, it doesn't work for whatever reason, the original setup remains in place. Alternatively, that the cars or vehicles put into a safe mode. That could mean all sorts of things. It might be sort of get you home facility. Could mean the vehicle just doesn't work. What that means in practice will need to be looked at. Just a couple of thoughts on that. If you're updating software for whatever reason, say it's to do with prevention of cybercrime, for instance, and you're defaulting back to the original system, now there's an implication that the existing system is not up to the job. It needs improvement, needs patches or whatever, just to make it more resilient. Now, how does that reconcile with the cyber management regulation? And also, if you look at, taking it a bit more locally, the Automotive and Electric Vehicles Act 2018 UK legislation, you look at the section to do with updates, that very much talks about ensuring successful update. Now, are you going to be in breach of that legislation, in particular if you don't successfully update or don't ensure updates? And I am paraphrasing slightly here, but basically the tenor of the UK legislation, if you don't properly do a download and update, you could reduce or undermine your or invalidate your insurance. So there are some anomalies or potential anomalies between local legislation and international regulation. Now, one hopes that, and I'm confident this will be the case, that the Law Commission, when they are looking at this, will identify this and see how the whole thing can be refined and ensure there are compatibilities. The other aspect is that there's an obligation to tell the owner or the user of the vehicle that updates are being done and what those updates are. Also, certain updates may only need to be or should only be done by skilled persons. So it's not like me, who dreads every moment I have to update my phone or my laptop. I go into blind panic. Now, the regulations state that certain updates might be such that they can just be done automatically at any point. Alternatively, they get the owner or the user of the vehicle to do it. Or thirdly, they are a nature that the vehicle has to be done by a skilled person, trained person. Also, part of regulations, you need to identify those updates that can be done at any point, even on the move, and that they won't affect the performance of the vehicle. Other updates may need the vehicle to be stationary, and as I say, maybe be done by a skilled person. And the other thing is also that the vehicle has sufficient power, and obviously this is quite applicable, relevant to electric vehicles, that they've got sufficient energy or power to ensure the successful update happens. So all these things are built into the regulations and the systems that manufacturers have to show that their software update facilities have. One thing under this regulation, it's not quite clear, is whether when does the obligation stops. I suggested, for the purposes of cybersecurity, it's so long as there's some form of obligation throughout the existence of vehicles on the road. Looking at the software regulation, it talks about keeping records for 10 years after the production of the vehicle ceases. it's not quite clear the ongoing monitoring and updating of the systems, software systems, how long that manufacturers are obliged to do that. And again, that's an area that needs, in my opinion, needs looking at. I think the key thing is that these two regulations I've spoken about today are, first of all, world firsts. One is very much geared to automotive or self-driving vehicles, but they have a role in any vehicle too. Well, semi-self-driving, still relying on a traditional driver. They also have an ongoing obligation. It's all about ongoing assessment and monitoring, and also collaboration, sharing of information. As I say, at the moment, it's limited to those countries that are members of the original 1958 agreement. As I mentioned earlier, the automated lane change system regulation was done under a different treaty of the UN, which also embraces the China and US. But it's good to see that there is a lot of collaboration between countries. There can be no doubt collaboration between manufacturers, have common interests to keep their cars safe, and also to avoid accident issues, also claim issues, and also just to give peace of mind to the consumer. And very much the regulations are geared at the well-being of the users and the consumer. This is still a new territory. We've got some new regulations out there. We need to see how they're going to be implemented in the UK, and I very much look forward to the Law Commission's report and findings on law and policy. That should be out sometime this year, but I suspect sometime post-September. When it is published, I'll be doing a sort of analysis of that and how it interrelates with the international scene. I hope you found this of interest, and as I say, if you have any questions or your own views on the magic, please do contact me. Thank you.
Hi, it's Peter again, and thank you for watching the session. Don't forget you can connect with all members within the EV community, send messages to each other, and start to build relationships for the future. Also, take a look at our supplier showrooms. Our partners have got lots of products and services that they have to offer, which again could be of benefit to you. Make the most of the opportunity, and thank you again for joining us.